Hello everybody, I hope you're very well. Thank you for joining us in our immigration webinar. I'll be speaking with both hats on as an immigration and an employment lawyer, and I'm joined with my senior associate, Rebecca, who's just waved.
Hi.
Right, so our agenda today is to talk about the new immigration system. And Rebecca, do you want to move the slides on? So we've been a year into this new points-based system, which is a variation of the old system. So just talk about where we're at there. I want to just remind people of perhaps looking at which is the best sponsorship license, or whether they what relevant visa categories would suit their businesses best. We're going to talk about the changes to the sponsorship management system. We're going to talk about the vexed issue of right to work following the EU settlement scheme and the changes that happened quite late on that scheme, and also the COVID concessions and adjustments. And we're also going to talk about finally the graduate visa route, and for one who's just got a graduate, there are lots of graduates out there that need roles. So we have this new points-based immigration system, but the immigration system has always been points-based. What we have now is, before there were various methods of being able to legitimately work in the UK, and now we're really divided into two. Those that have permanent rights to work, so say you have a British citizenships, permanent residence, all of those ancestry visas, all of those ones where you just need to do one check and they've got the lifelong entitlement to work in the UK, and those that don't. So these are from overseas countries, and also EU workers that haven't been in the UK before or taken advantage of the EU settlement scheme. So all of those who are either studying or working now need permission. We have two categories of sponsorship license, and most of you will fall into the worker sponsorship license. And this is where you're employing non-British workers on a long-term or permanent contract of employment. You're really looking at your skilled workers. You may have some intercompany transfers, and obviously there are some special categories of ministers and sports people. You can have also a temporary worker sponsorship license, and this may be if you're in the creative or sportive industries, so where you're looking at employees that come over for a very short term, maximum of 2 years, to do some project work. It's suitable for if you're a charity, if you've got some government authorised schemes, particularly the medical scientific community, if you have an international agreement worker, and also for seasonal workers. Employers may want to look whether they wish to apply for a temporary worker visa, and particularly I'm looking here at the seasonal workers, where there is now an expansion, and that might be useful for hospitality workers as that expands, and as we look at what's happening in our own labour market. Sorry, Rebecca, you went forward and then I still carried on talking, so can I have the next slide? So those of you that had the old Tier 2 general sponsorship licence, you'll be very pleased to know that that automatically transferred into a skilled worker sponsor licence. Those who had an intercompany transfer sponsor licence, that automatically transferred. And what happened is your certificate of sponsorship under each of those also transferred. What we are now seeing is that perhaps employers should look to see if they haven't got an intercompany transfer visa, they didn't previously need it. They might want to re-look at that if they're in a global group. Because of the changes in the immigration system, it means that an ICT worker could switch to a skilled worker much more easier. So it might be something you'd want to consider as a possibility. Can I have the next slide? So we have now the points-based system, and it's never been so easy to sponsor a worker. So you're looking at really good run rates on getting a sponsorship license. We're having no difficulties with the COSs, even though you may have the older numbers from previous, we are seeing the increase of those. And what you're also seeing is how the caliber of the candidates has then that requirement has lessened. I'm not saying your candidates are of any less caliber, but what you're seeing is now you have 50 points, and some of those are tradable. Before it was very strict definitions. They have to have a job offer from you. Their job must have a minimum skill level, and that's the equivalent of an A level, not a graduate. So there's a real reduction there. And as always, this requirement to speak English either in accordance with a standard test or the equivalent of GCSEs. And what we're seeing is these tradable points. So if they're in the shortage occupation list, or if there's some salary, you can use them. So if they don't meet one criteria, they can meet the other criteria. It's also now much easier to switch when you're in country. We don't have these cooling off periods. We don't have these periods where people have to go back, make an application. The only thing that, so you can see from intercompany to skilled workers, that could happen in country. If student visas, that can happen in country. You cannot do a conversion from a visitor visa or a short-term student visa into a skilled worker visa. So if somebody's on holiday here, I don't think that's probably likely in the current pandemic, but say somebody's using some other visa, just be careful about that. But then of course they can go back and make that application. So what you do is get your points, and points mean prizes, and then relatively easy to get. So what we've seen is the general salary threshold be reduced to 25,600, or the market rate, depending on the job. So if that's higher, it will be the market rate. But we've seen the reduction of the salary. You will get 20 points if the job is on the job, home office, shortage occupation, or they're holding a relevant PhD, so long as the salary is not 20,480. So the slides are quite detailed. We'll be sending a copy of the slides just in case you miss anything. And also, I forgot to say that we're happy to take questions. So if you start sending them in the chat box, we'll either try and do them as we speak or at the end. If you've got a PhD qualified applicant, the employer still needs to decide whether that's a relevant PhD for the job and whether it's an acceptable STEM subject. So some PhDs are more valuable than others. Can I have the next slide? So we've had, as I said, this reduction of the level of qualification, the general reduction of the salary by a significant sum, and in fact, employees can be paid less than that if they have enough of the other tradable points. And we put in the boxes what that could look at. Next slide. Employers will be very pleased to know that you no longer need to do the resident labour market test. This is previously where you had to advertise the job in 2 places for 4 weeks to say that yes, there was nobody in the local market that could do that job. That has now completely been scrapped. There's been the yearly quotas, so there's that awful period where we're waiting for the COSs on the 5th of the month to be given. That's not an issue. So what we are seeing is that actually this department is relatively processing both visas and sponsorship license quite well at the moment. So they're not being impacted like other government departments. I suppose I would just observe, with both hats on, both in immigration and employment, that there is something about employing, going through the process of doing a skilled visa application, both for the employer and the employee, which seems to make both parties concentrate on the relationship and ensure there's a really good fit. So, and that may not happen when you do your general recruitment. So it may be because they're behaving themselves because they got a visa, but you see some of the other issues that materialize when you're an employment lawyer, like attitude and performance. There seems to be that although this is a process which is still, takes you longer as a HR department, there is additional costs. There doesn't seem to be the run rate on the issues with hiring a poor employee which sometimes materialises with some of your other recruitment. And I'm sure, hopefully, you have very little people that have a lack of bill, but that's a theme that I think has emerged during the pandemic. I'm just going to pass on to Rebecca, who's going to talk now in detail about the points-based system.
Okay, so we're going to start with the intra-company visa, which has replaced the Tier 2 ICT visa. This visa is for existing skilled workers who are being brought over to the UK from a branch or subsidiary of the UK entity. So with this type of visa, the employee must have been employed at least 12 months in the overseas entity, and differently to the skilled worker, the required level is graduate level as opposed to A level, and the salary requirement is a bit higher, so it has to be at least 41,500 per year. With the intracompany, once in the UK, with this category visa, you cannot settle in the UK, but when you're in the UK, you can switch to the skilled worker route. And so that kind of opens up the option for UK companies to bring over overseas employees and then make a decision as to whether to keep them on permanently. As I said, you can switch in country now, and there is no English language requirement as there is with the skilled worker visa. So as a sponsor, you will have access to the sponsorship management system, the SMS, and this is what you'll use to manage your license. On the SMS, you must appoint what is called key personnel on your license, and what this includes is, firstly, the authorizing officer. This is the most senior person on the license, and this individual has to be employed by the organization, and they are responsible for recruitment of all migrant workers. They must ensure that all sponsorship duties are met, and they are liable for the actions of level 1 users. The key contact on the license is the individual who acts as the main contact between the sponsor organization and the Home Office. With the level 1 user, this individual will be the most active individual on the SMS. You can have multiple level 1 users. One of them should be employed by the organization, but you can appoint multiple level 1 users. For example, you can appoint your solicitor to act on your behalf. The level 1 user will do most of the functions on the SMS, including signing causes, reporting migrant activities, and informing the Home Office of any changes to the organization's details. On the SMS, there are multiple duties that you must adhere to as a sponsor. There are changes listed in the rules which need to be promptly reported, and any report that is sent through the SMS needs to be approved by the authorizing officer before it's done. If you fail to report material changes to the business, it could result in worst case scenario, license being revoked or suspended, and fines being issued. This is rare. This normally happens when there are multiple breaches on the license, and the Home Office is tipped off that something is not right. With sponsored workers, when there's changes in their circumstances, normally you have to report between 10 working days and 20 working days, depending on the type of change. What I want to emphasize is that even if you've missed this deadline of 10 working days or 20 working days, you should still report. It's better to report late than never reporting. Even if you report late, the Home Office might just accept the reporting and not enforce any action against you. So just a few points on terminology. Under the new system, Basically, even though the names have changed, they basically mean the same thing. So previously there was restricted cause, so cause is certificate of sponsorship, and there was unrestricted causes. Defined has now replaced restricted, and undefined has now replaced unrestricted. Defined causes are applicable to skilled worker migrants who you are sponsoring from overseas. They are allocated on a needs basis, and you need to request them individually as and when they're needed. It used to be that restricted causes, what they were previously known as, would take around 18 weeks to be processed, the requests, but now under the new system, they now take 1 to 2 working days, which is extremely helpful to the overall timing. Rarely the Home Office does ask for further information on role, recruitment process and the candidate, but that is rare. And then there's what is called undefined causes, which are applicable to migrants who are switching categories within the UK to the skilled worker or intercompany route, or for any other category visa from overseas. So just a few points to note with causes. Firstly, the immigration skills charge is payable for each sponsored worker, and you have to pay it at the same time as you assign the cause, and it will be £364 per year of the visa for a small business, and £1,000 per year of the visa for a large business. And to keep in mind when going through the recruitment process and bringing over a sponsored worker, you can only assign a cause on the SMS if it is allocated. So you need to think about how, before bringing over the worker, you need to time it so that you have the cause on the system to assign. On the cause, you will need to put the work start date when you are applying for the defined cause. For example, with COVID, there are travel restrictions, and sometimes the work start date can be delayed. So what you can do is add a sponsor note to the cause, informing the Home Office of this delayed date and the estimated new work start date. But it's important to note that the delayed date cannot be more than 3 months after the date of the visa application. And also some other timings to note: the visa application cannot be submitted more than 3 months in advance of the work start date on the cause, and the cause must be quote unquote used in a visa application no more than 3 months after it was assigned. It's quite a lot to adhere to, and we can guide you through the process if you require any further information. And the last point: if after a visa application is approved and the work start date is delayed by more than 28 days, in normal circumstances, you must stop sponsoring the migrant and report this on the SMS. So just a overview of right to work checks, which we will go into. All UK employers must hold a valid right to work check for all employees, including British employees. This right to work check must be done prior to the start of employment, and if done correctly, both manual in-person and online checks will provide what is called a statutory excuse against a civil penalty. With those workers who have a time limit on their right to remain in the UK, you will need to do a follow-up right to work check before their visa expires. So, as an employer, you must have HR systems in place which sufficiently monitor the immigration statuses of all employees, regardless of their nationality. You must keep copies of their relevant right to work documents. The system must track and record all of the employees' attendance at work. All of the contact details must be up to date. And most importantly, the systems must be organized so that a notification is triggered if a report needs to be made on the SMS. By implementing this type of immigration policy within your business, which is understood and followed by all employees, it will ensure that there is no mistakes made in regards to reporting duties. So the hot topic right now is the end of the EU settlement scheme, which ended on 30th of June. Prior to this, the Home Office had published that those EU nationals who did not apply by this date and who didn't have another form of visa would not be able to continue living and working in the UK. This has now changed, and the Home Office has updated their rules and guidance to allow for these late applications. And of course, with these late EU settlement scheme applications being accepted, this will change how you carry out your right to work checks. So what does this mean when you're conducting the checks? So retrospective right to work checks. I will let Mon take over on this slide.
So I've got the really easy slide, and I can see some of you are very eager asking your questions when we haven't finished all the slides, but I did ask for that. So this is one of the questions answered. I've got the easy part really. So if you had an EU employee working with you whom you had already done the right to work check, and they were an employee whose employment began on or before the 30th of June of this year, there is no need to do a new right to work check. Your old right to work check will be sufficient going forward, full stop. So this was a change that happened really late when we were coming up to the 30th of June. So I apologise to all those clients that were writing template letters to their EU workers saying, please, please. I think it's got something to do with the backlog of the EU schemes in place. But with my employment solicitor's hat on, I thought to myself, well, an employer's in a really difficult position because you cannot illegally employ a worker. It's a big no-no, you know, it's penalties, all of that, although it's very rare for that to happen. But the employment law would have protected these staff who had been working with you, who the law had suddenly changed. So I think this is a common sense, and it means that there's one other thing that you don't need to worry about. I would say that as we move into these new systems, you might, when you're doing your audits or getting people to do your audits, just make sure they're spot checking the original right to work checks, because that will give you some comfort that you've had a mock audit, if somebody's come in and they've checked it and you weren't highlighting any kind of issues. Rebecca's going to talk about actually the detailed right to work checks that you have to do for EU new hires.
So with new hires who are EU nationals on or after 1st of July 2021. So these EU nationals must provide either evidence of their status pre-settled or settled under this EU settlement scheme, or the scheme, which I'll call it, or evidence of a pending application to the scheme, or lastly, some other form of UK immigration permission, whether that is a family-based visa, points-based visa, indefinite leave to remain, or a myriad of other categories, which are endless, but just valid UK immigration permission. If none of the above can be provided during the course of the check, you should not employ the EU national. If an EU national comes to you and you're looking to hire them, and they do not have any of the above, you can signpost them to submitting a late application, but it's important that you can't employ them in the meantime. They have to have the right to work before you can bring them on as an employee. So next, I will talk about EU employees, existing EU employees who have been working for you before 30th of June or on 30th of June, they started, and new EU hires. And if they have a pending application under the scheme which hasn't been decided yet. So EU nationals awaiting decisions on applications to the scheme which they submitted by the 30th of June are permitted to continue living and working in the UK until a decision has been made. So for a right to work check, you may accept, while their application is pending, a digital certificate of application. Or if they don't have a digital certificate of application or it hasn't been issued yet, you can accept this EUSS email or letter acknowledging the receipt of their application. In addition to this letter or email, you also need to use the employer checking service to verify their right to work, and then also a copy of the response. I will go into what you need for the employer checking service. So firstly, it may seem obvious, you need consent from the new hire or existing employee to use the ECS. To submit a request on the ECS, you will need the employee's full name, date of birth, nationality, job title, hours they work per week, home address, home office reference number. You will also need to provide the name of your business, the business type, and contact information for your business. So last category is for those existing employees who are going to submit a late application to this scheme after 30th of June. So this may be relevant where, for example, you're conducting an internal audit to make sure your systems are up to date, to make sure that you have all the right copies of immigration documents for all your employees, and you discover that there is an EU employee who has not applied to the scheme and they do not hold another type of immigration permission, and for whatever reason a continuous statute excuse was not established in the right to work check conducted when they first became employed. So you may think that it's disproportionate or harsh to end their employment, and you believe they've missed that deadline due to circumstances beyond their control. So in reaction to this, the Home Office has implemented a transitional measure to allow employers to take certain steps in these circumstances. So currently this measure is in effect until 31st of December. Who knows, it might be extended, but as of now, it's until the end of the year. And so with this transitional measure, you need to follow these steps in order to be compliant with immigration. So firstly, you need to advise this individual that they have to apply to the scheme within 28 days. And they must supply you with evidence of that application. So as I said before, that could be either the digital certificate of application or the email or letter acknowledging receipt of their application. If after telling them they have 28 days, they don't provide you with evidence of their application, you must then terminate their employment. Secondly, once you receive evidence of an application submitted, you then need to use the ECS, and the ECS will provide you with what is called a positive verification notice, a PVN, if an application has been submitted correctly. This PVN will give you a 6-month excuse against a civil penalty, and at the same time allowing for the application to be processed. So before the PVN expires, you then have to carry out a follow-up right to work check on the ECS again. So there'll be 3 scenarios. So number one, when you do this second check on the ECS, if the application is approved, then the employee can then prove their right to work using the online service. And then if the application is still pending, it hasn't been decided, the Home Office will issue with you with a second PVN, a renewed PVN. And then thirdly, if their application has been refused, the right to work check on the ECS will come back negative, and then you should terminate their employment. So I'll let Monica just go over this slide with the COVID adjusted right to work checks.
So obviously COVID has completely changed our lives, the way we work, and including how you can do a right to work check. And Rebecca will talk about that in detail after me. But what we saw that was an extension from the 20th of June to the 31st of August. I'm just saying that there will be no further extensions to my mind. So if you're looking for people to start with you on the 1st of September, we are going back to the old-fashioned, looking at the original documents and having somebody there that can actually inspect those original documents or verify using the online service. If you have a check that was done via the adjusted system, which Rebecca will remind you of, between the 30th of March last year to the 31st of August this year, as long as that is compliant, and again your audit would just look through a few of them, check that it is, you do not have to do another return to work check. Rebecca, do you want to talk about just?
So there are quite specific steps that you have to follow when carrying out this adjusted right to work check. Firstly, you must request that the new or existing worker sends a digital copy of their right to work document via email or via an acceptable mobile app. Once you've received the document and it's clear and it's legible and you've reviewed it and you're happy with it, you then arrange a call with the worker via video. During this call, they should hold up their original documents to the camera, and then you must check the document you have via digital copy against the original document they're holding to the video. You must compare their physical appearance to make sure it's the same, details, make sure they are the same document. If during the call you are happy with the document, you can then say that you successfully carried out a right to work check, and you can make a record of this check stating that an adjusted check was undertaken on date due to COVID-19. So next I'm going to go into the immigration concessions that have been implemented since the onset of the pandemic. These are just a few, and they are changing what seems daily, but currently there are a few which are relevant to UK employers. So firstly, if you have a sponsored worker in the UK who has applied for an extension of their visa, or for they've submitted a change of employer application and they're awaiting a decision on their application, they can start working for you before they've received a decision on their application if, number one, their cause was assigned before the 1st of January, or they are applying for a health and care visa. Secondly, their visa application was submitted in time, and they have evidence of this in-time application being submitted. Lastly, the job that they are continuing in or starting is the same as the one that is listed on the cause that was assigned to them. Next, this concession relates to those overseas sponsored workers who are coming to the UK. So as you will know, with a visa application, the second step in completing that application is having the employee go to a biometric appointment at a visa application center. And due to COVID, a lot of visa application centers have closed at short notice, and due to local regulations, and there's no telling when they're going to reopen. So if, for example, you submit a worker's visa application, you book their appointment at their local visa application center, and then subsequently it closes, and there are no other visa application centers open in their country, then they are allowed to attend a biometric appointment in a different country. It's important to note that they're only allowed to do this if all visa application centers are closed in their country. So if one is open in a different city, then they must travel to that one. And they must also ensure that they check the COVID travel rules for the country that they're planning to submit in and attend the appointment. And lastly, to do this new appointment at a new visa application in a different country, they will need to withdraw and cancel their current application, and they'll need to submit a new application in order to book that new appointment. This concession has been extended once already, and it's currently in place till the end of the year, but it may be extended again. And then lastly, this is in regards to the entry clearance vignette, which is stamped in a sponsored worker's passport, allowing them to enter the UK. So this is different to the visa they get when they're in the UK. This is just an endorsement in their passport, which has to be kind of activated by Border Force when they enter the UK. So sometimes what happens is a sponsored worker their visa application will be approved, they'll get their endorsement in their passport, but then for some reason, due to travel restrictions because of COVID, they're not actually able to fly to the UK, so their vignette will expire. In this case, they can apply for a replacement. The cost is £154. But they will need to resubmit their biometric information. So they'll need to attend another biometric appointment to get this endorsement reissued. Also, once they've entered the UK, normally there is a time limit on how long they have to collect their BRP cards, so their biometric residence permit, which is their visa. Whilst COVID-19 regulations and measures are in place, they won't be penalized for failing to collect their card if for some reason they have to self-isolate. So we're just going to touch on a new category of visa. It's the graduate visa. This opened on the 1st of July. And it basically gives employers the opportunity to employ graduates, international graduates, without having to sponsor them straight away. So this visa applies to UK graduates who are on a student or Tier 4 student visa, and they have successfully completed their degree in the UK. If they have completed a bachelor's degree, this will give them a further 2 years in the UK. And if they have completed a PhD or doctoral degree, this will give them a further 3 years in the UK. And these are the main requirements for this visa. There aren't other criteria that need to be fulfilled. The main criteria is that they have this degree. There are no restrictions on their work in the UK. They can work for anyone, they can be self-employed. They do not have to actually have the degree certificate in hand. They can apply as soon as the university has let them know that they've completed the course. And it can't be extended, the graduate visa. So if at the end of the graduate visa you are looking to permanently employ these individuals, you can sponsor them on a skilled worker in country, so they don't have to leave the UK in order to do so. So now we'll be taking questions.
And I do have a long list of questions, so we'll go through the ones where I'm going to be a little bit more political. Rebecca, I'll answer those, and then you can disagree.
Okay.
Or delegates could come back to me on matters. But and if I misphrased your question, because I'm just seeing them and reading them out at the same time, just drop another note saying, oh, that's not what I was asking, just in case I got the wrong end of the stick. So the first question is, hi Monica, do you think the government would look to make sponsoring employees cheaper? In an answer, no way. You know, Rishi Sunak has a fan among middle-aged, overweight Indian solicitors. But he still needs to fill in the deficit, and I think it's not going to be they're not going to be any cheaper. There is already quite a lot of concessions they've made to employers, or they feel that they made concessions to employers. So I think that we will see, like with IR35, the other government measures, that they are looking to fill in their coffers. What I do say is we are entering a new phase now, and with this current political situation that we have, I do think employers should be lobbying. I think there is a real opportunity to make a change that suits your businesses. We were very proud of the work that we did with the furlough scheme. You don't do that alone, you lobby with others, you know, you can do that. So, and this is some of the questions that I will answer in the same thing. If you genuinely employ a lot of overseas workers into the UK, what you might want to do is look at your strategic plan about saying to the government, well, as a massive employer with this contribution into the UK, I'm talking about a very wide contribution, not just the tax contribution, what you're putting back into the community, the transfer of knowledge. You know, if you're helping schools and universities increase our knowledge base, then I think there is an argument that, you know, that would be, in my view, a very good way to effectively say it should be cheaper for us to employ when there is a deficit in the market. The next one is from a client of mine, and I knew that they would email me as soon as I said it. So as soon as I said that the seasonal worker visa, they could be used for hospitality, do you think the employers will have to be employed on a full-time basis? So what we're looking at is these new things and looking to expand those to suit clients' needs. And the person that asked the question, I was particularly looking, you know, to suit our needs for that client. I do think it's probably going to be full-time. I can't see it not. But then again, going back to this theme, that what I have seen is sectors work really effectively in the pandemic to, you know, to set out their position, how their industries are being impacted. So there might be scope that if somebody comes on a hospitality visa, that you could perhaps share that with another employer. Now, I am just, you know, making these things up, but they are the same kind of route. So you don't take away anything from the government's law. You're going to still abide by that, but you're saying, here's a different solution. But I do think actually it will probably be full-time unless we, you know, there's some change about them. So this one, Rebecca, you can answer this one. As licence holders required to request their yearly COS quota as previously required, are we still required to get our COSs even though they make no sense, they might change, we have no idea what we're employing?
Yeah, so the rules are a little less restrictive. So you do still need to request the allocation of your COSs, but it does not have to be as spot on as previously. So if you estimate that you need a certain amount of COSs, and in reality you don't need that much, that is not an issue. It has become easier as well to submit follow-on requests during the year. So say that you have not requested enough, you can submit a request for a follow-on allocation, and this can be expedited as well using the priority service. So it's not as restrictive as before, but you still do need to do the annual request for your COSs.
And then also, we answered one question in the slide, but question 5, when does the late applications for the EU SS close?
So we do not know this as of now. I think the Home Office is going to give quite a lengthy grace period. I would say at least another 6 months, but that is a hypothetical answer. As of now, they haven't given us a second cutoff date. And with late applications, they are treating them on what they are calling a discretionary basis. So we can't tell you that as of now, but I imagine that late applications will be accepted for the foreseeable future.
And then one which I will answer, I'll read it out in total, just so that everybody gets the nuances. With the right to work checks, doing so before employment, yes, well done. Is there a correct or legally correct time to do this before employment? Some candidates, job seekers for example, experience this from the point of making a job application through an offer being made, subject to checks being made, subject to an offer. Sorry, I think I might have read that out wrong. So what I think the question is saying is that when you're a job applicant and they're going through an agency, they are nervous about giving the agency their identity, even at the beginning of that job application process. Some nervous about the ID theft being requested so early in the process. Also differences in this between agencies, headhunters and employer recruits. Okay, so what you're talking about is a right to work checks, and they can't start to work with you until you've done the right to work checks. Right to work checks can be done by a third party, including agencies. What you're talking about here is data protection. So the applicant might say, well, I'm giving you these details, but you know, the jobs you may not give me a job that's applicable to me, I might not be interested in that job, yet you're taking my ID. So one of the things that you could be doing with your agencies is making sure that if they're going to hold that data, that their data protection comfort is there. So if they're saying to an applicant, your data is safe, this is how we hold it, it will be used for this limited purpose, we will destroy it, that might help people get over that issue. And plus, you know, most agencies or headhunters need to be compliant with the data protection, or you should not be using them. I do worry about when the employer doesn't do the right to work checks, and Rebecca might have a view as well on this, because ultimately it's on you the fine if that doesn't happen. So you'll be not only auditing yourself, you'll be auditing them. We've just done with our commercial department an agreement for a recruiter to provide employees into a client, and you should have seen the schedule on right to work. So we said, yeah, you can do the right to work, but the schedules that we drafted for the compliance on that was quite stringent. So my view to the question is that I think at the beginning of the process it probably is too early. It might be when you've seen the CV and you want to move it on, that might be an appropriate junction, because it's this idea of not wasting your time if you want somebody who has got the right to work in the UK. Obviously discrimination issues aside, but that is still a legitimate one that is proportionate. I wonder whether that will change with us all working from home and, you know, doing the job wherever you can do. So before this coming online, Rebecca was talking about whether she should go on holiday or not, and you know, I'm thinking, well, she can do her job quarantined. So I'm thinking, okay, you know, it's this idea that where can we work? So I hope that answers that question. So I think that they can do it, but maybe in a more legitimate part of the process, and I would still probably want the employer to do it just to have that protection for the.
I'll just add, I understand for large businesses, it seems, it may seem more economical to outsource the right to work checks. There are agencies that do right to work checks, but at the end of the day, as Monica said, liability will fall on you. And so if you are having third parties conduct your right to work checks, I would ensure that with each one, they are sending you copies of which checks they carry out, so that you can check their right to work check. if that makes any sense. But on the same point, that could just create additional work. So it is a kind of controversial issue, but I always advise that employers do it on their own.
So question 7, with many interview processes continuing to be virtual after the 1st of September, do you have any advice on how to practically manage the in-person return to work checks from the 1st of September, particularly for non-office based roles? Well, that is a catch-22 question, because obviously there is the other option of the online checking if that's available. But the reality is that once the interim COVID measures go, where they're waving things in front of the video camera, it will be an in-person check. So it may be that would be the stage where you're getting a cohort across, that we're part of the induction, we're meeting up with them in some way, and the people that are meeting up with them to do part of their training, if it's in person, would be also able to check. So for example, we offer a real-time service where if somebody's having a difficulty on their check, they just dial us up, we're online with them, we talk them through the check and they do the check, but they've got that support mechanism. So it may be that combining both of the questions, that in some cases it's better to earlier do the test check in the recruitment process, and it might be part of your wider idea about onboarding. So I am very relaxed. I have said to my staff, we will come back when we've done all our risk assessments, when people are comfortable. If you want to come in, you can come in. It's very safe. Both Rebecca and I are in the office. We don't have such decor at home, but so it may be that part of the onboarding and making people feel embedded would be some in-person meeting. Now, I do realise that it really does depend on the role, and I know who the question is from, and I do realise that they have a lot of workers where over the UK where that just may not be practical, but we are reverting back to those. If you're going to do them, have somebody trained up. It doesn't need to. It doesn't need to necessarily be a HR person, although you need to show the training. And then I think the last question is, can a sponsored employee enter the UK from a red list country? So over to you, Rebecca.
So this is quite a common occurrence these days. So the short answer is yes. A sponsored worker can enter the UK from a red list country. Any sort of visa holder can enter the UK from a red list country, but they will have to undergo government managed quarantine, as we've all heard on the news. So what this means is they have to go into 10 days of hotel managed quarantine. They'll need to take a COVID test before they come into the UK. They will need to book what is called a quarantine package with the government. And as part of this, they'll have to take tests during their quarantine on days 2 and 8. And currently the cost of this is quite high. It's $17.50. So that is something to think about when you are planning the visa process with these sponsored workers, who's going to outlay these costs. And then lastly, they'll have to complete what is called a passenger locator form, which is an online form giving details of where they've been prior to entering the UK, where they plan to stay. And it's important to note that they shouldn't complete this form until they've booked their package, their government package. These are the rules right now. They could change. Everything is changing on a daily basis, but as of now, yes, you can enter the UK as a visa holder from a red list country, but you have to adhere to these strict requirements.
We've got a few more questions in, so we're not quite done, and we've got 5 minutes in any event. So next question, graduate visa question. Is there an age restriction on this, i.e. mature student with a degree? Could they qualify? Rebecca, over to you, but I think I know the answer to this.
No, there's no age restriction. So long as they have at least a bachelor's degree that was undertaken in the UK, and they were, sorry?
Yeah, I think the question derives from that other jurisdictions do have age restrictions on their visa, so I can understand why the question was asked, but no, age is something, you know, that obviously I would say we get better with, but hey ho. The next graduate question is, how is a graduate visa different from the startup visa for those graduates looking to start a business?
So a startup visa is a much harder visa to obtain. You require an endorsement from a government approved body to get a startup visa. And this is really competitive. With a graduate visa, you don't require any endorsement. The only thing you require is that degree, that UK degree. So I would say for those graduates who want flexibility on their work, I would say go with the graduate visa.
Sorry, I just, let me open up the app again. Last question, do you have an obligation to become a sponsor license holder? i.e., can I refuse to employ someone that does not have the right to work in the UK, or would this be discriminatory? So the answer to that is, there is, are you employing somebody because of, or not employing somebody because of their race? The question is no. You're not employing them because they don't have the right to work in the UK, or because their sets of qualifications and their experience is not relevant to the role. So the answer is you've got no obligation to be a sponsorship license holder. We would encourage you to be that so that you can employ people that fit on all of those criteria, but even if you've got one, doesn't mean that you have to offer an overseas individual a job. So there are costs involved, there is their experience involved, and whether you think that this is a mechanism for them wanting to have to get into work with you within a certain jurisdiction. And these are all reasons where you can say no. I don't know the makeup of all of the people on this list, but there are many of us employers that hybrid working will not work, and there will be lots that will be doing hybrid working, and there'll be very few people that are genuinely remote, can work from home. And so we're talking about the class where they could even argue I can do that anywhere, would be a very small point. And also I would say that as we're in this period, we can all see the disadvantages of working entirely at home, and therefore this idea to meet up even on occasions, you know, in person is still very relevant. So I would have, again, very good criteria of why you're rejecting somebody, which is not based on any discriminatory grounds, but if they don't fall within that criteria, you're absolutely acceptable to not employ them. That's it, I think. That's the, and oh yeah, 1 minute to go, so that's quite good on timing. Thank you very much for joining us. We hope you found this informative and useful. If there's any questions that we've not covered up, or you want to have a further discussion, just please email Rebecca or I. Thank you so much.
Thank you.